All right. Good morning, council. This is case number 122628, Smith and Everett versus Barton and Associates and others. This is the third case on our docket for the August 10th panel of the Kansas Court of Appeals. My name is Steve Hill. It is my honor to be the presiding judge in this case, and I am very happy to be on the same panel with Judge Gordon Atchison and Judge Sarah Warner. All of us are long-term members of the court, and we're ready to go, I think. So, counsel, we have received your briefs and have read them, of course, and we have received a memorandum of law from our research staff concerning your case. And we may have some questions for you. So let me start now with the appearance of the appellant's counsel, please.
Raymond Salva and Mark Parrish on behalf of appellants.
And are you wanting to reserve any rebuttal time?
5 minutes, Your Honor.
5 minutes. Let's see, now this has been granted 20 minutes for both sides. Now, I want to tell you all that we will penalize no attorney if they want to not take up all of their time. So feel free, if you're done, to say you're done, and it won't hurt your case at all. Now, 5 minutes, you've got it. Then for the appellees, please.
Thank you, Your Honor. May it please the court, Sean Edwards appears on behalf of Safeguard Properties Management, LLC.
All right. And let's see, I think there were two others, but they're gone now. Is that correct? Two other parties?
There was one other party that I believe is gone, Your Honor.
All right. Very good.
My mistake. There are two: an individual and a corporation. So
I thought I could count to two. Thank you, counsel, for clarifying that for me. All right, let's hear from the appellant. Counsel, what went wrong?
Well, Your Honor, there are two issues that the appellants bring to court today. Following a grant of summary judgment in favor of the appellees in December of 2019 by Judge Mahoney in Wyandotte County Division 7. The first issue is whether the district court erred in granting that summary judgment on the grounds that appellant could not establish a claim of negligent misrepresentation against appellee Safeguard. And the second issue was whether the district court erred in granting summary judgment on the grounds that Safeguard's misrepresentations as to the condition of the property were so technical in nature that they fell outside the typical jurors' common knowledge requiring expert testimony. And one issue dovetails into the other. As to the first issue, the district court erred in finding Safeguard owed no duty to the appellants because the parties were not directly in contact during the time Safeguard carried out its responsibilities at the property at issue in this case under contract with its customer, Chase Bank. However, as the Kansas Supreme Court instructs us, in some cases, a third party may have an action against a tortfeasor without having any direct communications from the defaulting party. In addition, the Supreme Court instructs us that one who makes misrepresentations or concealments is subject to liability for damages to a person or class of persons whom he intends or had reason to expect to act or refrain from acting in reliance upon those misrepresentations or concealments.
And it is your argument that that rule applies here. Is that correct?
It is, Your Honor, yes.
Explain that to me.
Well, the court in DeBoer, which appellants referenced in their brief, lays out the framework of Section 522 from the restatement section of torts that requires a party to present evidence sufficient to satisfy two elements of a negligent misrepresentation claim when the parties are not in direct contact. The first prong of that in this case would be, and that what the appellants allege and brought evidence to support, was that Safeguard intended for the commercial information that it provided to guide and influence the appellant, or Safeguard knew its customer, Chase Bank, would provide that same information to the appellant. That's the first prong, that it knew what, in one way or the other, the information was going to travel to somebody with whom it did not have direct contact. And in that case, that's the appellant. The second prong of that is that through reliance upon that information, Safeguard intended to influence the appellant to do something. Or alternatively, Safeguard knew Chase Bank intended to influence the appellant with that information. And so where we found error is that the district court focused on whether Safeguard, a property preservation contractor, performed work on the subject property that fell outside the applicable standard of care for a property preservation contractor. And in doing so, the district court determined that expert testimony was necessary to assist the jury in understanding whether Safeguard performed its duties in an appropriate fashion, in a workmanlike fashion.
Counsel, doesn't that really conflate these two issues, though, that we're talking about? Well, we have two separate claims, one for negligent misrepresentation and one for negligence. And so my question to you is, just because you started with the negligent misrepresentation claim, how do we have justifiable reliance in this case?
Well, as to there were, prior to the appellants taking possession of the property, Safeguard, while it was under contract with Chase Bank, communicated to the bank that it would winterize the plumbing in the property. And so Safeguard placed these bright orange winterization stickers on all the plumbing fixtures, like the stools and sinks and bathtubs. And that sticker stated in part that the sole purpose of a winterization is to prevent damage from freezing pipes. And so that message satisfies the second element, which is justifiable reliance, that through reliance upon that information, Safeguard intended to influence the appellant, because a jury could determine that the appellant relied on that information, that the pipes were preserved, to waive any further inspection as to whether the pipes were indeed damaged from freezing.
But the thing that your client would have to prove is not just reliance, right? I mean, that's a factual determination, whether your client actually relied on these alleged misrepresentations. That's maybe a question for another time, but the other thing that you would have to prove is a question of law, and that is whether that reliance was reasonable, was justifiable.
It was, we believe, Your Honor, that it was justifiable because it was directed, even though these parties had no contact, it was directed to the homeowner appellant. The going back to the sticker again, the first sentence on the sticker states that a winterization was performed at the property pursuant to a work order issued by your mortgage company. So in that message, Safeguard was speaking to the homeowner directly, and not Chase Bank. And so by putting that message out there that the winterization was performed and it's to protect your pipes, would lead a reasonable person to believe that they need not investigate further as to whether those pipes were actually safe.
So the sticker that in and of itself is actionable, and the homeowner wouldn't have to do anything else to investigate, say, when the sticker was placed.
There's more to it than that, though. In addition to the stickers, there was a sign-in sheet where the Appalese contractors would come in and out of the property from time to time. They would put a date and an initial and a brief description of the condition of the property. The appellants discovered that sign-in sheet prior to taking possession of the property during an inspection. And so that notified them that, hey, somebody has been coming into this property on a regular basis, conducting an inspection, and that would further inform them as to whether or not whether the appellants needed to investigate further as to the condition of the pipes that were behind the wall.
And if those sign-in sheets said things like fair or fair to poor, is that then that's enough and the homeowner doesn't have to do anything else?
Well, Your Honor, the significance of the sign-in sheet is not that Safeguard placed a subjective rating on the property, which required an expert to assist the jury at trial to understand what fair or poor or what any kind of property condition means, as the district court, I believe, erroneously concluded, but rather that Safeguard made regular visits to the property. And that's what the appellant took from that. And that supports her argument that there was reliance, that somebody was taking care of this property for a year or more, and that coupled with the winterization stickers, there was nothing to inform the appellant that there was something wrong. Now, unbeknownst until this lawsuit was filed to the appellant, there was a long history of attempted repairs and mold remediation going on that Safeguard had conducted for a year. As a matter of fact, one of the records show that leading up to conveyance of the property, Safeguard had reported things to Chase Bank, its customer, that pressure tests on the plumbing had failed even after the premises was winterized, that it treated the premises for mold damage, that a hygienist should be retained, and then that it obscured mold damage with stain blocker and paint. And yet just prior to appellant's occupancy, it communicated to the bank that the property was in, and it's quoted, convey condition, meaning.
Counsel, I just want to make sure that I understand that argument and place it in context. Is that argument doesn't certainly go to the negligent misrepresentation claim, right? Because your client couldn't have relied on that if your client didn't know about it until the lawsuit was filed, correct?
That's correct.
So that goes to the second claim with regard to the standard of care and the negligence and the actions that should have been taken.
Well, Safeguard was in the property, and they took the time to place the winterization stickers, which communicated a message directly to the homeowner. Safeguard could have spent 1/10 of the effort in affixing those labels by merely posting a notice that the pipes were broken. Now, Safeguard may say we don't do that. Our customer is the bank, not the appellants, but Safeguard made sure to address the homeowner directly in the first few lines of that statement on the sticker, where it references the appellant's mortgage company. And Safeguard made sure to address the the appellant directly in a warranty disclaimer that's also on the sticker. And so Safeguard had ample opportunity to do anything. It didn't have to make a special trip. It didn't have to engage. The appellants directly. Just posting a notice like it did to convey to the appellants that nothing was wrong. They could have posted the truth, which was something is wrong.
The sticker says it was winterized. Is there any evidence that it wasn't winterized, in fact?
Yes, there was evidence that it wasn't winterized. There was a pressure test conducted on the plumbing at some point after the winterization had been undertaken, and it failed the pressure test. That communication was conveyed to the bank, but never to the homeowner.
Counsel, you have 2 minutes left in this portion of your argument.
I'll reserve that for rebuttal, Your Honor.
All right, you still have your 5 minutes of rebuttal. I didn't mean to cut you off.
Oh, okay. Getting to one of the earlier questions, the winterization sticker also states the plumbing system should be dewinterized by a licensed contractor or plumber before the water's turned back on to make sure that everything in the system is operational. And the appellant did exactly that in the spring of 2017, but by then the damage had already been done, and that damage could not have been discovered because it was, again, concealed with stain blocker and paint. Again, information only available to Safeguard and that Safeguard kept to itself. So appellants were justified in relying on the winterization stickers as to the condition of the pipes because there was no visible damage to the premises. Again, but because of the stain blocker and the paint. And appellants were aware that Safeguard made regular inspections to the premises as evidenced by the sign-in sheet. Those two facts coupled, which were also available in our argument to the district court, we believe satisfies the two-pronged test set forth in DeBoer and establishes a claim of negligent misrepresentation.
Thank you, counsel. We'll turn now to the appellees. Counsel, you have 20 minutes. Are you ready to proceed?
Your Honor, thank you.
Go ahead.
Thank you, Judge. Counsel has completely skipped the issue of the necessary experts here, and I want to get to that in a moment. But let's address a few things a few misstatements that have been made. Counsel continues to talk about misrepresentations or concealments by Safeguard. None of that happened. Safeguard, let's just be clear the lay of the land here. Safeguard is a contractor for Chase Bank. Chase Bank was the lender on the property before this appellant was involved. Chase was the lender for her father when her father owned this property. Chase was not her client. Safeguard was not her client. She never engaged their service. She never reached out to them. She never contacted them. Safeguard was a stranger to this appellant. There are no misrepresentations. This appellant simply never reached out to Safeguard. Safeguard's telephone number was printed right on that sticker. This appellant never reached out, never contacted Safeguard, never called Safeguard to say, what's going on with this house? This appellant received this house in a descent and distribution action in probate court and made the decision to take out a mortgage to pay off Chase. She made that decision sight unseen. She didn't do any due diligence. She didn't have any inspections of this property. And after the fact, after she got herself into this money pit, she comes looking for someone to blame for that. And she comes and blames a stranger, Safeguard, who had no interaction with her, made no misrepresentations or concealments. She simply never reached out to them. Had she reached out to Chase, had she called Safeguard the information was available. It's not that it was withheld from this person. This person never went looking for it. She didn't.
Counsel, let me ask you a question.
Yeah.
In Safeguard's business, why do they use bright orange stickers?
They use bright orange stickers because they've winterized the property, and they do not want anyone to come along and damage something by trying to utilize either the HVAC or the plumbing before a professional can come in and unwinterize it.
So they want these notices to be noticed. That's why you make them bright orange, right?
Certainly, they want people to come in to not damage the property by doing something they shouldn't do with the HVAC or the plumbing. Correct.
That's right. And so they want them to be noticed, and surely that's notice to the entire world, is it?
Well, Judge, noticed that the property's been winterized. That's certainly not. That's not an announcement that this property is available for habitation. Should be purchased sight unseen. There's nothing on that sticker that says come on in and buy this property.
It's not. You're saying it's not a representation of condition.
Absolutely, it's not. Absolutely, it's not. And they go on to talk about this check-in sheet. There's a check-in sheet for these contractors. These contractors have specific jobs. Their purpose for being there is to preserve this collateral for Chase. Chase has a mortgage on this property, and Chase has an interest in making sure that their collateral on that loan is not damaged. And so they send these contractors in with very specific marching orders. Go in and do this for us. Go in and check on the condition of the property. Go in and make sure that the property is preserved so that the time comes we have to foreclose on this property, that we've got some collateral to foreclose on.
So did this appellant have a right to rely upon Safeguard to do it correctly? That if you winterize this, the pipes shouldn't be broken, right?
Judge, the facts will show that we weren't even sent to this property until December of 2015. It had been previously abandoned by the plaintiff's father and her family, and it was left abandoned and unattended with no heat and no electricity. So the people she inherited this property from left it to freeze before we were ever involved. So the day we show up, it's had months of opportunity for the pipes to freeze. We're not guarantors of the condition of the property. We don't arrive on scene and repair everything that's on the property.
So those are factual questions as to causation, though, right? I mean, those would be questions that you would make to a jury if this case were to go forward. But here we have summary judgment, and so I'm trying to figure out whether, for example, this the people she inherited the house from, her father, was her father within the zone of communication for these stickers? So, was he relying on these stickers? I mean, this notion that just the fact that she inherited this house and thus she's removed from any chain of liability seems a bit stretched.
Well, Judge, the fact remains is she's relying on two things. She's got these stickers that just inform her that it's been winterized. They tell her nothing about the condition of the property. They make no representations about the condition of the property. The only other thing she relies on is a check-in sheet where each of the contractors that come and go wrote one word. They wrote the word fair. There's no representation on that document about the condition of the property. There's no representation on that document about the habitability of the property. And she never reaches out to anyone. She doesn't have any context for that at all. She doesn't know who these people are. They're strangers to her, these people that wrote the word fair. And she now comes back after she's made this mistake and is trying to say, well, I relied on that. That's not justifiable reliance to see a word written by a stranger, never speak to that stranger, never follow up with that stranger, and have any context for something they could call justifiable reliance on that one word.
Was there evidence in the record that the winterization was not done correctly? Mr. Salva alluded to that in response to one of my questions.
No, Your Honor. There was a pressure. I believe there's evidence of a pressure test later that the pipes or fail the pressure test. That doesn't mean that the winterization was done poorly. That just means that when Safeguard arrives on the property, they find it as is. And if there's damage to the walls or damage to the pipes, that's what they are, what they are. That we're not tasked.
Well, okay. Yeah. Does the record indicate that the pressure, I mean, I'm unfamiliar with pressure tests, but does that indicate that there was some damage to the pipes as opposed to it wasn't winterized? Or is there anything in the record about what that means?
Not specifically, other than just a report from the contractor saying we completed the winterization, and there was a subsequent pressure test in which the pipes did not pass that pressure test. That's just that was written in the record. That was passed along to the lender. All that information was available to this appellant, by the way, and she just never bothered to go get any of it. She didn't follow up at all. It would have been provided to her if she just asked for it. She'd found it in discovery in this lawsuit instead. And I do want to get to a point that you've raised, Judge Atchison. These are all technical questions. All of this information, all of the issues about training and expertise necessary to be a property preservation contractor, the responsibility of a property preservation contractor in securing, maintaining, and preserving property, the extent to which a property preservation contractor would be required even to do any evaluation of the property, and certainly critically in this case, the duties of a property preservation contractor are all questions for an expert.
And I wanted to ask you about that. Is there a national agency that promulgates standards for property preservationists?
There's certainly a national association. I don't know that there's necessary, because you got to understand that property preservation is a broad spectrum practice. It involves plumbing, it involves painting, it involves.
And that's kind of what I'm trying to get at is you're saying, well, you got to have an expert as to what the standard of care is. Well, if there is an established standard of care within the industry, and I'm asking you, what is the source of a standard within the industry for property preservationists? I mean, it's not like accountants where you've got the generally accepted accounting principles. It's not like appraisers where you've got USPAP or whatever, I mean, the acronym and all. I mean, it's not that kind of defined profession. So what is it the expert's supposed to testify about? I mean, what is the standard?
And Judge, I would address that to the specific tasks that were carried out by the property preservation contractors. This court, as we pointed out in our brief, termite inspections require an expert opinion or an expert to define what the standard of practice is in a termite inspection. As a practical matter, a property preservation specialist could be tasked with doing a termite inspection, could be tasked with examining plumbing, could be tasked with construction, wall, paint, mold.
Let me back up. Was there ever a final pretrial conference and final pretrial order entered in this case as to the claim? I mean, I tried to find one because I was a little confused about plaintiff's negligence claim. Do you recall?
I don't recall offhand.
Okay, I couldn't find it. Anyway, my point, what I wanted to get at was, it seems like reading the amended petition, the negligence claim they're making is a failure of your client to give notice. It's not a claim that the winterization was substandard or the mold remediation was substandard, and those might require some expertise to say, yeah, that's below the standard of care. That's not how you remediate mold. It seems to me do you disclose that there's mold isn't so much a question of standards and experts as either you have a duty to do it or you don't have a duty to do it. And it's probably a common law tort duty. And it may even be defined by the contract between your client and Chase here, what its duty was. I mean, you see the distinction I'm making there?
Judge, I do, and I think the district court looked at that distinction too. And as a practical matter, first of all, the district court concluded that is also a subject of expertise. What duties even run to strangers to my client? We need expert testimony just to identify what in the world our duties even are. And as a practical matter, this hypothetical, I think, would suggest that if I have someone come paint my house, and then 2 years later, I sell my house to someone, that my house painter from 2 years ago has some duty to notify the buyer of my house of the condition of the property. See, we're a step removed from these people. We're strangers to them.
Well, I understand, and but that's not a question of expertise. That's a legal question of what the duty is, isn't it?
And it's a legal question that the district court concluded that the arguments about these duties of these third parties is inapplicable in this case, and that was a conclusion that the district court reached, and I would agree with them that the arguments that counsel made that they're a third party that somehow a duty or responsibility flows from Safeguard to them. The case law that they've cited doesn't line up with that. Those third party cases are all about when a contractor puts a piece of property into commerce. Safeguard never owned this property. They were just
Counsel, it seems to me you're arguing that that's a question of law. That's not a question of fact.
True.
Whatever duty a party owes to somebody else, that's a determination for the court, correct?
I would agree with that, Judge, yes.
And what was the determination of the court here?
That duty did not run to a third party like this. That was the determination that the district court made.
Counsel, you keep saying third party, and I just want to make clear, is there any difference in this case, since this isn't like an unattached buyer later on down the line? This is the heir of the property owner at the time that this was being conducted. Is there a difference legally there?
Well, I think there's certainly an indistinguishable difference factually. Safeguard has no idea who this person is, who the heirs of. As a practical matter, when Safeguard goes to this house at the behest of Chase, they don't even know who the owner is. Okay, that's not in the.
Does Safeguard have any duty to the owner of the house?
Just basically
the existing owner of the house at the time that it's conducting the
I think
work.
Sure, I mean, basic duties of to not damage the property probably, but in terms of duties that would run to whoever the current property owner either sold it to or passed it to through inheritance, those people are strangers to Safeguard. They would have no means of contacting them, no means of reaching. As a matter of fact, the converse is true.
I mean, I think what Judge Warner is getting at is whether there is like some form of privity between the plaintiffs here and her father as the owner at the time, because it never was completely foreclosed. I mean, he continued to be the owner with redemption rights that she was then exercising. Is there some kind of, I mean, whether it's strictly speaking privity, but is there something because of that relationship that any duty owed the actual owner would flow through to the plaintiffs in this posture, I think is what we're getting at.
Right, and I'm not aware of any such flow of duty that would go from this.
Okay, well, and I think that the predicate question then is your position that your client owed no duty to the owner of the premises because it was employed by the mortgage holder. And its only duties were the mortgage holder, other than to not commit waste, for example, to go in and intentionally damage the property by breaking out windows or something. Indeed,
Your Honor. Yes, that's the duties that the contractual duties that flowed from my client to Chase are the sum total of their duties.
Okay, so if your client was like grossly negligent or something, the plaintiff's remedy would be against Chase for hiring somebody who was grossly negligent. I mean, the claim would be against Chase because that's who they had a legal relationship with, is your position.
Indeed. And in fact, yes, Chase was the former mortgage holder on this property. Correct.
All right.
Getting back to the expert issue, I mean, ultimately, all of these questions, it is our position, it was the position of the district court, require expert opinions, whether you're going to talk about the work that was done, whether you're going to talk about the duties that run. All of that requires expertise. This court has been consistent in holding that even something as routine as a termite inspection, opening up a wall and looking for termites, requires an expert opinion as to the duties that run from that activity and to whom those duties run, and the duties that inspector carries out. Property preservation inspector is exactly the same. They do termite inspections, they do plumbing, they do drywall and painting. All of that is necessary that an expert opinion be offered, so that the jury doesn't have to just guess as to what the duties are, whether those duties were breached, and whether there were damages. It is important to point out too here, this appellant doesn't even have an expert to quantify or identify her damages. She has an invoice or an estimate from a mold remediation company that's 6 months after the fact. It's here.
That's not the basis for the summary judgment, though.
It's not. But the court did address that in its summary judgment order.
Counsel, you've got about 1 minute if you want to sum up.
Thanks, Judge. Ultimately, the two critical questions are there's the expert issues, which I've already addressed, and then the fact that there's simply no evidence here that the applicable standard of care was breached by Safeguard, or that Safeguard owed duties to these individuals to whom they never spoke, to whom they were strangers, and to whom they had no contractual or business relationship whatsoever. Thank you.
Thank you, counsel. All right. Counsel, you've got 5 minutes if you want to. You may begin.
Before you get all wound up, do you recall whether or not there was a final pretrial order entered in this case, just off the top of your head?
I do not, Your Honor. And my leaning is that there was not.
Okay. Now, sorry to interrupt you, but
no, that's okay.
Momentum forward here. Go ahead.
I will pick up where counsel left off with respect to the need for expert testimony in this case. In this case, the jurors would have been capable of understanding that when an entity represents that a home was winterized for the purpose of protecting pipes, when in fact it possessed superior knowledge that those pipes were broken, a breach of a duty has occurred. Likewise, the jury would have been fully capable of understanding that Safeguard possessed superior knowledge of water leaks that caused widespread damage in the walls of the property, and again, failed to either fix the pipes or warn of them that a breach.
Would a jury need to be instructed, or would evidence need to be submitted about what a property preservation professional would do in those instances?
The record contained hundreds of emails that set out in exhaustive detail all of the tasks that were undertaken by Safeguard during its year-long maintenance of the property.
And I understand that. My question, though, was a little bit different. It was, assuming that there was a problem with the pipes at the time that this was winterized in the first place, or that the Safeguard, your argument is that Safeguard should have undertaken some other steps later on when they found out about some of these issues. Wouldn't you need someone to come in and explain why that is the case in light of what property preservation professionals do?
I don't think so, Your Honor. And I think you framed it earlier when you said that this was more of a failure to warn type scenario, where the party that had the superior knowledge either kept it to themselves or concealed it. And so that truly is the crux of our case. And that's why we say that, the jury would have been capable of understanding that Safeguard's use of a stain blocker to obscure the damage without disclosing it, as it had done so directly to the homeowner, just as it directly addresses homeowners in its self-serving warranty disclaimer, that a breach of duty had occurred. I mean, the jury box is full of homeowners who know at a very basic level that broken pipes cause damage to homes and lead to bad things like mold. And that's all they needed to know to understand this case. There was never any critique. There was never any complaint about the quality, content, or quantity of the work or any tasks that were undertaken by Safeguard in this matter. It was simply that the message that was conveyed to the appellant was that, hey, everything's hunky dory with the pipes. But one other thing that I wanted to hit on before my time runs out. Counsel stated that Safeguard is not guarantors of the condition of the property, I believe. Yet that it is a property preservation contractor. And so I take from that label that one of their duties is to, as Judge Hill alluded to earlier, was to preserve the property, was to not let it go into waste. And if I assign that to you, Judge Hill, and you didn't say that, I apologize. But they did have, they did take on this duty to take care of the property. Winterization goes to the condition of the property. A pressure test, a failed pressure test, goes to broken pipes, which is a condition of the property, and Safeguard knew those pipes were broken.
Counsel, you've got about a minute left.
So to sum this up for the court, the district court should have denied Safeguard's motion for summary judgment on, at a minimum, plaintiff's negligent misrepresentation claim, because the appellants did come forward with evidence to establish that Safeguard made material misrepresentations in the stickers and concealments with the painting over the mold stains that it intended for, or had a reason to expect that appellants would act or refrain from action in reliance on those misrepresentations or concealments. And Safeguard's misrepresentations and omissions were not so technical in nature that they required the explanation by an expert witness. And I would thank the court for its time today.
All right, thank you very much, counsel. All of you, a very interesting case, some interesting arguments. We will take the matter under advisement and in due course issue our written opinion. Thank you very much. With that,